To help you better understand what happens in a small claims case, King County District Court has produced several brief videos. In this video, Judge Raul Martinez explains why the court requires the parties to the case to participate in mediation, and what the benefits of mediation are to you, whether you are the plaintiff or the defendant.
King County District Court's local court rules on small claims require the parties to mediate before a trial is set. Even though the court requires mediation, we hope people will mediate in good faith because there are significant advantages to mediation over a small claims trial. Mediation is a private discussion between the parties. The judge and court staff aren't present. Instead, a highly trained mediator with the King County Dispute Resolution Center conducts the mediation. The mediation occurs in a private room on Zoom, and no one is going to know what was said in the mediation, not even the judge. Some of the advantages of mediation are that people who mediate their small claims cases are usually much more satisfied with the outcome of their case. People can craft a flexible agreement through mediation. They can agree to do something or not to do something. People who are owed money are much more likely to be paid if they mediate because they've arrived at a mutually satisfactory agreement during mediation. On the other hand, a party who wins a trial only receives a judgment saying somebody owes them money. The judge doesn't order the losing party to take out their checkbook and pay them right then and there. Collecting on that money after trial often involves hiring a lawyer and other court processes such as garnishments and liens. Even if the parties don't resolve their dispute through mediation, we find that they are better prepared for trial. That's because they've had a preview of the other side's evidence and a preview of what the other side thinks about that evidence. Another benefit of mediation is that it's private, whereas small claims trials are public. We have open courts in Washington state. That means every word somebody says in court is a matter of public record. Every document, photograph, and piece of evidence they provide to the judge during the trial also is public record. The public is allowed to come and observe trials, and they're allowed to request documents and the audio recordings of the trial after the fact. On the other hand, mediation is private and is not part of the public record. And because mediation occurs on Zoom, people don't need to come to the courthouse in person for a small claims trial, which can help them save time. The most important thing about mediation is that it's about self-determination. There's a problem. It's not going away, and so the question is, how will the problem be solved? When you come to a small claims trial and the judge swears you in and you describe your version of what's happened, what you've done is just given the judge the power to make a decision about something that affects you. In contrast, when the judge gives you a mediator, you now have a resource to help you and the other party talk constructively about the issue and make that decision for yourselves. Some of the possible outcomes of mediation include that the parties could end up agreeing to resolve their dispute out of court, meaning that there will be no trial. If the dispute is resolved, the mediator will help the parties write an agreement that could be enforceable in court if one party doesn't live up to what they said they would do. If the parties don't reach an agreement through mediation, that's fine. The court will set the case for a small claims trial in one of our courthouses.